I beg to mention for listing a case, my lord. My lord, what happened, my lord, on 10th of this month, my lord, the case was listed before his honorable court, but my name was not shown, my lord, I missed the item, my lord. Matter is extremely urgent, my lord. Can it be on tomorrow, my lord?
What is the matter?
Matter is criminal revision, my lord.
Okay. Okay.
Yeah.
Yes, allowed.
I will similar period, Lordship, on the next week, Lordship, any date.
Next week on a date to be fixed by registry.
Monday, Lordship, 22.
No. Let the registry be.
Well, in respect of item number 48, I have filed an it's a bail application, my lord, wherein by order dated 3rd of September, the Lordship was pleased to grant interim protection to the petitioners. Subsequently, the petitioners came to know regarding addition of additional sections. Accordingly, this IA has been filed, my lord. May I pray this matter be taken up immediately after motion, because so that I can record my statements, my lord, before the investigating authority.
No, we'll take it up. Item number 48.
Yes, my lord.
We'll take up when you are directed to appear.
We are directed to appear within 50 days, my lord. But the thing is that after
We'll take it up when the matter is called.
additional sections has been added, therefore I have not.
Wait for your turn.
I think I put about 56 supplementary list.
Yes.
Maybe fixed on Friday, my lord. 19.
Why?
Today I have some difficulties, my lord. I have to leave the court, my lord.
Next week.
On Friday, my lord, 19. It's motion matter.
Heard Mr.
Yes, Islam.
S. Islam learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty. Let this matter be listed on 19th.
19.
Okay.
Obliged.
May it please your lordship. Lordship, I beg to mention a criminal petition for admission, my lord, on this Friday. Why it happened, my lord, by making this mention, my lord? Owing to the urgency, my lord, this matter was by order listed on 29/8. Unfortunately, could not reach, my lord. My lord, the victim is also here, my lord, for the respondent number 2, my lord. It happens to be between a husband and wife as of now, and some issues regarding going abroad, my lord. And the hindrance is because of the pendency of the case. May I pray, my lord, Friday for admission, my lord? Earlier also it was listed, did not reach. Then we tried with the registry as well.
Okay.
Friday, my lord. Obligement.
Lordship, I beg to mention item 18. It may be
18.
18, 1.
Yes.
May be taken up next week, but my senior has some.
On request of
One.
Leonard Counts. What is your name?
M. Ali.
On request of Mr. M. Ali Learned Counsel for the petitioner. This matter is adjourned. Let this matter be listed in the next week on a date to be fixed by registry.
But on 24th.
No fixed date.
All
Let registry.
Lordship, I beg to mention item number 19, Lordship. Lordship,
Yes.
prayer for adjourn the matter for the day.
Heard, Mr. What is your name?
A.R. Mandal.
K.R. Mandal.
A.R. Mandal.
A.R. Mandal, Learned Counsel for the petitioner who prays for an adjournment.
Lordship, on Friday.
The prayer is allowed.
Friday.
The registry will fix the date.
Friday.
May I please, your lordship, for listing of a criminal petition, your lordship. As per this court order, your lordship, this matter was sent for mediation, your lordship, and the matter has been settled between the parties, your lordship.
Settle.
Yes, your lordship. Kindly matter be fixed tomorrow, your lordship, because the local matter is fixed on 19, your lordship. For admission, your lordship.
Tomorrow,
Your lordship, before
tomorrow
19.
it will not reach. If we start fixing as per your request, it may not reach, and then again you will pray. Let the registry fix the matter in the next week.
My lord, is a criminal revision petition, my lord. This matter may be listed on Friday, my lord. Matter released to, we have challenged the prayer in respect of 125 PR.
Let the registry fix it.
Next week, my lord. Next week, date may be fixed by the registry.
Next week, okay. Okay.
May I please your lordship, I beg to mention item number 59. And I want to order the bail petition.
What is your prayer?
Lordship, party not interested.
What is your prayer? You are
Your
seeking,
lordship, I want to order the bail petition.
huh?
I want to order. Order the bail petition.
What is your name?
Islam,
Your name is not there.
on behalf of Anna Ahmed.
Yes, your name is there. Heard Mr. Islam, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. We are allowing withdrawal. The prayer is allowed. This petition is dismissed on withdrawal. Let the case diary be returned back.
May it please your lordship, I beg to mention for listing a criminal revision petition for motion lordship on Wednesday lordship, motion matter lordship.
When have you filed?
Lordship, I have filed on lordship 18/7, lordship, there was an IA lordship, which was subsequently allowed. Delay condemnation was there, lordship. There is a prayer for stay also, lordship. Motion lordship, Wednesday lordship,
Okay.
oblige your lordship. Lordship, I beg to mention for listing one criminal appeal.
Next week on a date to be fixed by registry.
There
Next week on a date to be fixed by registry.
is an IA for bail.
Next week.
May I please your lordship? Lordship, I beg to mention item 5 of court number 21. Lordship, matter may be come after week. Any date, lordship?
If it is not urgent, you need not to mention. It will be otherwise. Only urgent matter is to be listed. So you pray before registry.
Lordship.
Item 1. May I please? This is an application under section 480, my lord. And the accused was arrested, my lord, 24/07/2025, my lord, 54 days in custody, my lord. An allegation, my lord, under section 21B/29 of NDPS Act, intermediate quantity, my lord.
How much is the contraband?
Contraband, my lord. As per FIR, my lord. Recovered item, my lord. Suspected.
Case diary. Heard Mr. T. Hussain, learned counsel for the petitioner. Also heard Mr. K. Das. Call for the case diary. Let this matter be listed
22nd.
on 22nd of October.
60 days mandatory, my lord, 54 days in custody.
When the 60 days will,
60 days will be, my lord, 54 days, my lord. After
19th.
90. Bibliography. Item 2.
May I please your lordship? The second time application. The earlier lordship rejected this application from basically on the grounds lordship that the embargo incorporated in section 37 of the NDPS lordship.
Is pending investigation.
No, lordship, trial is going on.
Now,
As on date,
what?
lordship, 6 witnesses has been examined out of 9 as mentioned in the search sheet lordship.
What is the, how long you are behind the bars?
Lordship since 1st of July 24 lordship. 1 year lordship around 2 months.
What is your ground?
Basically, lordship, the thing is that when first application was made, our basic contention is that regarding the dispute with the informant and this petitioner. There is some personal dispute lordship, the grass of this petitioner along with this informant.
No, that was,
That was the regular subject. Now, lordship, as on date, lordship, they have examined 6 witnesses out of 9 witnesses. So if lordship go by the evidence adduced by all these witnesses, except the informant, lordship, there is nothing against this petition, number 1. Number 2 is that, lordship, the prosecution has not followed the procedure as incorporated in the rules 22 of this NDPS rules, lordship. Basically, lordship, after seizing the article, this informant has not, lordship, followed the procedure, and basically, lordship, yes, lordship, can you see the evidence reported by PW 5 and 6.
heard Mr. J. Kolita, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This is for the second time the petitioner is approaching this court seeking bail in an offense which involves commercial quantity of contraband. The perusal of the scanned copy of the trial court records as well as scanned copy of the connected case diary would be necessary to appreciate the contentions of the learned counsel for the petitioner, hence call for the same. The registry to take steps for requisitioning the scanned copies. Let the 17th of October.
Obliged. We have to. Intermediate 23 lordship, then CD में call lordship and
Heard Mr. M.
25
Khan,
or
learned
27.
counsel for the petitioner. Also heard Mr. K.K. Das call for the case diary. Let this matter be listed on
Lordship 25th,
25th of
September.
September.
Obliged.
Item 4.
Succeeded matter lordship. The Commissioner Vijayendra was since 204 days lordship. He was arrested on 25 to 25 subsequent succeeding file lordship under section 6 of post lordship.
Heard Mr.
AK.
A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the scanned copy of the trial court record along with the connected case. Scanned copy of the connected case diary. Let notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondents within 3 days from the date of this order,
Yes,
returnable on 15th of October.
yes,
List according.
obliged.
Right, please, your lordship. Today's 48 days. Will it accept section 67A manner, other is valuable. The 60 days is statutory period manner. In the informant's case is that the present petitioner introduced with her that is another religious person. In fact, my lord, both are in classmate in same college now.
Case diary would be required. Heard Mr. Ainuddin, learned counsel for the petitioner. Also heard Mr. K.K. Das. Let the case diary be called for.
26.
Let this case be listed on 26th of September.
Item 6.
My pleasure, lordship. Lordship, regular bail application as on today 30 days, POXO is there, my lord. I am paying for CD and
Heard
notice.
Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for this case diary and issue notice to respondent number 2. Same order, petitioner to take steps within 3 days. Returnable on
Before vacation last day.
15th of October.
Item 7.
Yeah, please, dear lordship. 483 application, arrested on 25 as of today, 22 days lordship. FIR is at page 8. But in similar type of case, absolute recovery has been made lordship. Taken into custody, fully interrogated. Nothing was recovered after nothing was given. Case 15 is the second forwarding report. Nothing was there in the forwarding report. In a similar cases, the coordinate bench of this honorable court was pleased to grant bail on the very first day itself, lordship. These two are orders, lordship. 7 is bailable in nature, lordship. And no license is required for reciprocal about 2,000, below 2,500, lordship.
Why your prayer was rejected by the trial court?
At this stage, kindly see the order, lordship.
We are calling for
Page 17. 18, at this stage, that it was
after perusal of the case.
case diary. Nothing, only incriminating materials, nothing was there, lordship. Only,
We'll call for the case diary.
lordship,
Fixing
so
it.
that within Guwahati, lordship.
Heard Mr. A.K. Soikia, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case then. Let this case be listed on
Well, before Lordship, 24th Lordship. I have another case here, Lordship. 24th.
Agotipupani. 25th.
Deeply obliged.
Item 8.
May it please your lordship. Same CD has been called in another bail application, which is fixed on 17th of this month. Your lordship, both the matters will be taken.
Heard Miss N. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that in a connected case arising out of same police station case number, case diary has been called for and the said case is fixed on 17th of September. She submits that this case may also be taken up and fixed along with the said case. The prayer is allowed. Let this case be listed along with bail application number. What is the number?
Your lordship, BA 2869
A 2869
2025.
2025 on 17/9/2025. Upward liquor call for the case study.
Highly obliged, your lordship.
Let me close it. This is an regular bail petition for a recovery of heroin, 5.23 grams only. Accused is behind the bars for last 23 days.
We'll-
FIR is at page 14, relevant
We'll
part of
call
FIR
for
is
the
at page
case study.
5.23 grams lordship, only and he is for 23 days already. Schedule that definitely reveals the same thing. Maybe investigation has already been over, only for pending for this.
We'll
Report of
fix.
the FSL. It is in the 5.2 at page 14 lordship,
20.
page 14, 5.23 grams.
For
39 of small containers,
how long you are behind the bars?
23 days, since 25.
Still we intend to peruse the case then, fixing a short date.
That's what that.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. All for the case study.
23 lordship,
Let this case be listed on 23rd of September.
obliged.
Item 10.
PD may be called for.
Heard Mr. D.K. Agarwal, learned counsel for the petitioner. Also heard Mr. K.K. Das. Let the case diary be called for.
Unfortunately.
What is the offense?
Intermediate for the NDPS,
How long you are behind the bars?
more than 17 days.
26th of October, September.
26th of September, same.
Same order.
Item 12.
May I please your lordship, kindly matter may be passed over after some time, your lordship.
Okay.
Obliged, your lordship.
Item 13.
CD may be called for.
Heard Mr. D.K. Agarwal, learned counsel for the petitioner. Also heard Mr. K.K. Das, call for the case diary. Let this matter be listed on 26th.
Much.
Item 55 from supplementary list.
This is clear bail application lordship. In this case lordship, my name is not appear in the FIR lordship. But here in this case lordship, the other two accused already been arrested and subsequently one vehicle is already been recovered and handed over to the registered owner of the vehicle lordship. Lordship, kindly come, FIR will find page number 10 lordship. Petitioner is a student lordship, his name is not in the FIR also lordship.
Vehicle already been recovered. May I read page number 10.
What is the offense?
Offense is 3032 lordship. Well, and the one accused lordship, I have also annexed the lordship and lordship. Seizure list lordship will find page number lordship 16. Well,
Why are
already,
you apprehending your arrest?
lordship here, the accused Noyan Jyoti Sokia lordship is my cousin brother lordship. On the date of occurrence lordship, while the police intercepted the vehicle lordship, and then police got red-handed, and subsequently he contact me lordship for help. That because I am the family member lordship. And accordingly, I have informed the other guardian lordship, and on that basis, lordship police searching me lordship. And my I-card is page number 17 lordship. Only
No.
20 years boy lordship. Vehicle already been recovered lordship, page number 16, the seizure list.
Where is the statement that you are apprehending arrest? Which paragraph?
Lordship, page number 16 lordship. Sorry, para number 6 lordship. Para number 6, page number 5.
The police has not searched.
Charge lordship.
What is the basis?
Lordship, the arrested accused Noyan lordship is my relative lordship, cousin. And I have the forwarding report also lordship. I am providing lordship. And he contact me lordship, that because and he is similar age me lordship and same family member. This is the forwarding report lordship. Already they are also released on bail lordship after 14 days.
What is this for?
Lordship.
Why this forwarding, you're showing this forwarding report?
Other two arrested, my cousin also, and they are already released on bail.
No. What is the basis of your apprehension if you are not involved?
Date of arrest lordship, my cousin, and he contact me over telephone lordship after arrest lordship.
Then
So police searching me lordship.
where is that statement then?
Lordship, para number 6 lordship I have mentioned. And
These are your assumptions. Police has not searched for you.
call me lordship and they were.
Why have you not stated that police has called you? Show me the apprehension. There is no apprehension.
Mention lordship, I have to mention lordship.
Find out or bring it on record, otherwise it will be dismissed. You are unable to show it.
After 5 minutes lordship, just.
Okay,
After 5
we'll
minutes,
take it after some time.
lordship.
Item 12.
I'm sorry.
Yes,
This case, my lord, the name of the petitioner does not appear in the affair. If you also kindly see the affair page 12. 2 persons were arrested. The name in the affair, page 12, my lord. And that
yeah.
because number 1, name in the affair, page 12.
Yes.
He was already arrested and released on bail,
No, why
Now-
are you apprehending?
my lord.
Why are you apprehending your arrest?
Because, my lord, I went to police station to know what of the allegation against Agus number Saizul Islam. Then, my lord, police searched me and try to threaten that I will be arrested in this case. This is the only reasons.
because I wanted a police station. Otherwise, there is no, our name not appear in details in the affair.
Where is the statement that police threaten you?
My lord, paragraph 9.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Rahul Khan, who is apprehending his arrest in connection with Kokrajhar PS case number 131/2025 under section 303 within bracket 2/317 within bracket 2/317 within bracket 4/313 of BNS, read with section 13 within bracket 1/16 of the Assam Cattle Preservation Act and section 11 within bracket 1 within bracket D of the Prevention of Cruelty to Animals Act 1960. The gist of accusation in this case is that on 31/5/2025, one Deepak Kumar Chauhan, SI of police, had lodged an FIR before the officer in charge of Kokrajhar police station, inter alia, alleging that the Gaubura of Salbari village informed the officer in charge of the Kokrajhar police station that some villagers have detained a four-wheeler vehicle along with stolen cattle and also a motorcycle suspected to be of the thieves. Accordingly, a police team along with the informant went to the spot and arrested the owner of the vehicle bearing registration owner of the vehicle. Who are the two persons? Both are owners.
Hello. Another is the owner of the vehicle.
Owner of the vehicle. Learned counsel for the petitioner has submitted that the petitioner has not been named in the affair and is in no way involved in the offense alleged in the affair. However, he submits that he went to police station to know as to how. Who is Saizul?
Saizul is the owner of the bike.
How Saizul is involved in the offense alleged in this case. At that time, police, the investigating officer threatened him that he may also be implicated in this case and may be arrested to stop. Learned counsel for the petitioner has submitted that though petitioner is in no way involved in the offense alleged in the affair, however, he is ready to cooperate in the investigation. He is, however, apprehending his arrest due to the threat given to him by the investigating officer. On the other hand, yes.
Call for the CD and station calling for the.
On the other hand, learned additional public prosecutor prayed for calling of this case diary. Let the case diary be called for. Let this case be listed on 24th of October. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the petitioner, namely Rahul Khan, is directed to appear before the investigating officer of Kokrajhar PS case number 131/2025 within a period of 7 days of the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority
Hello.
with following conditions.
55.
List as
I'm sorry, my lord. And I have very clearly mentioned in my petition, para number 4, lordship. Para number 4, lordship. And CDR lordship and the police found during the course of investigation lordship, police received the CDR, and on the basis of CDR lordship, my phone call was found with the arrested accused Noenjyoti Sokia lordship. On that basis lordship, and there is the police calling me to appear before the police station. On that basis, there is the severe apprehension. I'm very clearly mentioned.
heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Deep Jyoti Soikia, who is apprehending his arrest in connection with Dhing PS case number 201/2025 under section 303 within bracket 2 of BNS. The gist of accusation in this case is that on 17/8/2025, one Dildar Hussain had lodged an FIR before the officer in charge of Alamgaon outpost under Dhing police station, inter alia alleging that on 15/8/2025, some unknown miscreants have stolen the Bolero pickup van of the petitioner, of the informant, bearing registration number AS01C9717 from the courtyard of his residence. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. However, after his arrest, in this case, who has been arrested?
Noenjyoti Sokia, Mehfuz Alam Shah, Noenjyoti Sokia, and one Bastop Sokia.
3 accused persons have already been arrested. And one of them, namely Noenjyoti Sokia, who is the cousin brother of the present petitioner, had called him, or called the petitioner over mobile phone, and the police, on the basis of call detail reports of the phone number of the apprehended accused person, has been calling the present petitioner to appear before the police station. Though no notice under section 35(3) of BNSS has been issued in this. What is the punishment? 303.
3 years.
No notice under section 35(3) of BNSS has been issued to the petitioner. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. However, he is apprehending that if he appears before the investigating officer without any protection, he may be arrested. On the other hand, learned additional public prosecutor prays for calling of the case diary. Let the case diary be called for. Let this case be listed on 23rd of October. In the meanwhile, however, considering the submissions made by learned counsel, as it is written, 30,000 with 1 you appear within 7 days.
Lordship, deeply obliged, Lordship, deeply obliged.
Item 14 and 15.
Wait, please, Lordship. Lordship, this is a joint petition, Lordship, husband and wife. Filed before this honorable court for quashing this 498 cases, Lordship. Lordship, in the last occasions, Lordship, a report was called for. As because, Lordship, this joint petitions file along with an compromise deed has been annexed. So ultimately, Lordship, a direction has been given to the petitioners to appear before this court below. And court below will be send a report on the basis of whether that deed has been executed or genuine or not, Lordship.
Whether that report has arrived.
Lordship, and on last occasions, Lordship, on 27/8, in dispatch section of this High Court, Lordship, I have said that the report has been received.
Received.
Yes, Lordship, but that report is not tagged with this case report, Lordship.
Okay, we will direct the registry to take the report.
Lordship,
Heard Mr. PC Day,
Lordship, I have, Lordship,
heard Mr. Ihawk.
Lordship.
Ihawk, learned counsel for the petitioner. Also heard Mr. KK Das, learned additional public prosecutor.
In this way, I see.
It appears that it is long back. It appears that by order dated 29/5/2024, this court had called for a report from the trial court regarding the veracity of the compromise agreement entered into between the parties to this case, within bracket joint petitioners. Learned, the said report is not available in the case record. However, learned counsel for the petitioner submits that he has verified from the dispatch section of the registry and has been informed that a report has been received by the registry of this court. Sub-registry to verify the same and tag the report along with this case record on the next date fix and place the report in this case record on the next date fix if it is found to have been, if it has been received.
Kindly maybe fix this matter up day after tomorrow, as because Lordship that in trial court, this matter was fixed on 29.
What is this matter?
Day after tomorrow, Lordship.
On 17/9.
I listen.
Item 16.
May it pleases your lordship, can you pass me the matter for the day, lordship? There is some difficulty.
Heard Miss
P. Devi on behalf of Mr. S.P.
B. Devi, appearing on behalf of Mr. S.P. Chaudhary, learned counsel for the petitioner, who prays for a short adjournment. The prayer is allowed.
Deeply.
Item 17.
This revision petition has been filed, my lord, against the my lord conviction under section 25, my lords, and directed to undergo, my lord, imprisonment for 3 months, my lord,
For
by
3
trial court. And my lord, appellate court also affirmed the said judgment. So my lord, a relevant portion, page 31, my lord, can be seen. the order of the trial court.
On what ground you are challenging?
My lord, the serious ground is there. Number one, my lord, cross case is there. I have certified of the cross case, my lord. I could not earlier submit, my lord. I have my certified in my hand, my lord. A cross case, my lord, it is the mandate of Honorable Supreme Court to my lord to try to get her. Cross not, my lord, try to get her. That case is still pending. And the second ground, my lord, is under section 4 of PO Act, my lord, I have, my lord, with several judgment of Honorable Supreme Court. It is the duty, my lord, of the trial court in such cases, my lord, to release.
You are convicted under what provision?
Section 325, I think so. And 3 years, 3 months, my lord, imprisonment. And my lord, the FIR was lodged after 7 days. That explanation not at all in the FIR. And my lord, there was marpit among both the sides, my lord, in front of the gate of the petitioner. It is admittedly, my lord. So, my lord, this there may be call for my lord.
Heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. K. Das, also heard Ms. N. Das, learned additional public prosecutor. This application under section 442, read with section 438 of BNSS, has been filed by the petitioner impugning the judgment and order dated 25/2025. Passed by the Court of Learned Additional Session Judge Udalguri in Criminal Appeal number 30/2024, whereby it upheld the judgment and order dated 30/11/2024, passed by Learned Chief Judicial Magistrate Udalguri in the PRC case number 126/2024. Stop. By the impugned judgment of the trial court, the petitioner was convicted under section 325 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 months and to pay a fine of rupees 5,000, and in default of payment of fine, to undergo simple imprisonment for 2 months. Stop. Issue notice to the respondent number 2. Since Ms. Hendas, learned additional public prosecutor, has appeared for the state of Assam, no formal notice need to be issued to the respondent number 1. As regards respondent number 2, the petitioner shall take steps for issuance of notice upon the said respondents within 7 days from the date of this order, returnable after the date of this order by registered post with AD, as well as by usual mode, returnable after 4 weeks. You have any interim prayer?
My lord, I already filed my lord, 1016, my lord.
List accordingly.
My lord, in the meantime, my lord, on the 7th of 9, my lord, 7th of September, he has been arrested, so my lord, he may be granted to, my lord, trace bail.
Heard in interlocutory application, heard Mr. S. Chauhan, learned counsel for the applicant, also heard Ms. N. Das, learned additional public prosecutor. This application under section, this application has been filed by the applicant for suspension of sentence imposed on him by the impugned judgment dated 30/11/2024, which was upheld by the judgment dated 20/5/2025 in criminal appeal number 30/2024. The said judgment has been impugned by the applicant in the connected criminal revision petition number 375/2025. By the impugned judgment, the petitioner was impugned judgment of the trial court. The petitioner was convicted under section 325 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 months and to pay a fine of ₹5,000, and in default to undergo further simple imprisonment for 2 months. Learned counsel for the petitioner has submitted that the petitioner has preferred a criminal revision and preferred the connected criminal revision petition against the impugned judgment and is hopeful of getting a favorable result in the said criminal petition, revision petition. He also submits that considering the short term of sentence imposed on the petitioner, unless the execution, further execution of the sentence imposed by the impugned judgment is stayed during the pendency of the connected revision petition, the said revision petition may become infructuous. I have considered the submissions made by learned counsel for both sides. Considering the short term, considering the fact that the connected revision petition, in the connected revision petition, notices have been issued to the parties, and also considering the fact that the sentence imposed on the petitioner by the impugned judgment is a short-term sentence of only 3 months. This court is of considered opinion that this is a fit case where the sentence imposed on the petitioner by the impugned judgment may be stayed during the pendency of the connected criminal revision petition. Same is accordingly done. Stop. The petitioner is also allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Odalguri in PRC case number 126/2024, with a condition that in the event of dismissal of connected revision petition number 375/2025, the petitioner shall surrender before the trial court to serve out the sentence imposed on him by the impugned judgment. This interlocutory application is accordingly disposed of.
Item 20.
Yes.
It's under maintenance, my lord. What is the, go back in 31/8/2023, interim order of materials was granted of ₹6,000 without taking into the assets and liabilities as per decision of NAHA.
31/8/2023.
23, man. Now what happened, then we filed one application for modification of order, considering the fact that the appeals court way back in 2021, my lord, Rajesh versus NAHA, my lord, assets and liability has to consider before passing any order of maintenance. whether interim or. And that order was rejected on 3/5/2025. Your lordship file, that is under challenge, my lord.
3/5/25 you are challenging.
Yeah, both the orders I have challenging, but 3/5, but because we have brought to the notice of the court, that is the law, my lord, that has to be taken into consideration before passing any interim order. And that, because she is an earning lady, my lord, and she has her own income. It is not that she doesn't have an income to maintain herself, my lord. That is the one prerequisite for passing an interim order. Now your lordship file,
Are you paying the money?
yes, we are paying the money, but there maybe some area is there, right? I cannot say exactly, my lord.
Pay for 1 more month. We are issuing notice
The interim order will consider next then.
after service of notice.
I understand, my lord.
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard state is named party,
State actually, no party is not there.
state
Comment,
is
my
not required. Also heard Ms. N. Das, learned additional public prosecutor.
lord. Also,
This application under section 528 of the NSS has been read with section 19 within bracket 4 of the Family Courts Act has been filed by the petitioner, namely Shantanu Bhattacharya, impugning the order dated 30/5/2025 passed by the learned Principal Judge, Family Court number 3.
3/5, my lord, not 35, 3/5.
Sorry, 3/5/2025, passed by learned Principal Judge, Family Court number 3, Kamrup Metro and Guwahati in FC within bracket criminal case number 331/2020, whereby it upheld the order dated 31/8/2023 passed in FC criminal number 331/2020, whereby interim maintenance was awarded to the respondent number 1. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
The date may be fixed.
After 4 weeks, 1. Returnable on October 29, least accordingly.
That day, my lord, that matter maybe can be before.
Interim,
Yeah, that will consider that.
the prayer for interim relief shall be considered on due service of notice upon respondent.
May I please, your lordship? Lordship, this is a pre-year bail application earlier rejected, lordship. The petitioner is coming up for the second time, lordship. Okay, in the meantime, lordship, investigation has sufficiently progressed and one of the accused person has already been enlarged on bail. So lordship may ascertain from the case that lordship, what is the stage of investigation?
Heard Mr. A. Ganguly, learned counsel for the petitioner. Also, what is the offense?
Offense, lordship, theft.
Also heard Ms. N. Das, learned additional public prosecutor. Call for the case diary. Let this matter be listed before vacation due. 25th of September.
Black.
This criminal petition has been filed for issuance of NBW lordship by the learned trial court lordship. Okay, they will appear and cooperate with the investigation lordship.
What is the offense?
Offense under lordship 341 IPC, 364A IPC lordship. They were previously arrested lordship and were enlarged on bail lordship.
Then what happened?
Hereafter lordship, impugn order is at page 37 lordship. An extra E, the lordship.
You filed an application
Lordship,
that was rejected.
Lordship.
Heard Mr. P, let him appear. Heard Mr. P. Bordole, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Samiran Sakyar and Ranjan Kumar Giri, who are impugning the order dated 28/7/2025 passed by the learned session judge Vishwanath in sessions case number 126/2024, whereby non-bailable warrant of arrest were issued against the petitioner. Learned counsel for the petitioner has submitted that the petitioner are facing trial under section what, under what provision charge sheet has been
Lordship, page number 35, Lordship.
under section 341/364A/34 of the Indian Penal Code. During investigation, you were,
Arrested, Lordship, and later on released on bail, Lordship.
during investigation,
Lordship. Before filing of search.
stop. Learned counsel for the petitioner has submitted that the petitioners received summons in the aforesaid case and had engaged their counsel who filed an application before the trial court showing cause of their absence on 28/7/2025. However, the Court of Learned Session Judge Vishwanath rejected the said application and issued non-bailable warrant of arrest against them. Learned counsel for the petitioner has submitted that the petitioners were arrested in connection with this case and during the course of investigation, and they were also allowed to go on bail. Stop. He submits that the petitioner, why you could not appear on that day?
Lordship, due to medical ground, I have submitted the petition, Lordship, which was
That-
subsequently rejected.
That the petitioners could not appear before the trial court on 28/7/2025 due to some medical conditions. Stop. And have engaged the counsel who had filed petition number 2098/2025 showing cause of the absence of the petitioners before the court. However, same was rejected. Learned counsel for the petitioner submits that next date of this case is fixed on 23/9/2025, and the petitioners are ready and willing to appear before the trial court on the said date. However, they are apprehending that since a pending non-bailable warrant of arrest is there, they may be arrested at any time. So I have considered the submissions made by learned counsel for both sides. Considering the facts and circumstances of this case, as well as considering the fact that the petitioners are ready and willing to face the trial and cooperate in the trial, this criminal petition is disposed of with a direction to both the petitioners to appear before the Court of Learned Session Judge
Vishwanath.
Vishwanath in Which case?
In sessions case number 126 of 2024.
In sessions case number 126/2025. On the next date fixed, that is 23/9/2025. Stop. To facilitate their appearance before the trial court, the non-bailable warrant of arrest issued against them by the trial court shall remain suspended till that date. On their appearance before the trial court, the petitioner may seek any appropriate relief to which they are entitled. This criminal petition is accordingly disposed of.
Obliged, your lordship.
Getting B, item 27.
Yes.
In this case, your honor, your lordship's matter relates to POCSO, your lordships.
Here again, Lordship, the up-to-date status report was called for, it has not been achieved. Because on the last occasion, Lordship, I had placed before Lordship that the case is already fixed for argument, Lordship. 313 statement has also been recorded. And it was way back, Lordship. It was fixed on Lordship 14/8/25 for argument. So probably by now, Lordship, it may have been over.
Your lordship, judgment has been pronounced, your lordship, it's in the judge.
Judgment has been pronounced. What is the result?
Conviction.
Ruled by your lordship.
Heard Mr. S. Islam, learned counsel for the report has come. Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Ms. M.K. Brown, learned amicus curiae, appearing for respondent number 2. On last occasion, that is on 28/8/2025, a report regarding up-to-date status of the trial pending against the petitioner was called for from the trial court. Accordingly, the status report has been received. Where is the status report?
Become tolerant.
How it is.
That was- On perusal of the status report furnished by learned additional session judge from special judge POCSO Kamrup Metro, it appears that in session special case number 36/2025, the judgment was pronounced on 6/9/2025, and the petitioner was convicted under section 6 of POCSO Act, as well as under section 65 within bracket 2 of BNS, and was accordingly sentenced. In view of the conviction of the petitioner in the sessions special case number 36/25, this application under section 483 of BNS has become infructuous and accordingly disposed of.
Kindly pass over the matter for timing must be based on other board.
As well as the service report for service of notice has also not been issued.
Service report is not there.
Service report is also not there, Lordship, and also the scan copy trial court record also not there.
What is the name?
J.A. Sigdan.
Heard Mr. J. Singh, the learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 10/9/2025, it appears that the scanned copy of the trial court records, which was called for, have not yet been received. Has not yet been received. Registry to issue reminder for the same. Learned counsel, learned additional public prosecutor also submits that the service report of the notice issued to respondent number 2 has also not been received. In view of the same, learned additional public prosecutor is requested to get an information regarding fate of the notice issued to respondent number 2 from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed on 25th of September.
29. CD received. No, please, your Lordship. There was call for lodging. And 19 days behind the bar lodging, the page 8 is the FIR.
How many days behind the bar?
19 days.
What is the offense?
Possibly, says that he has a heart for slaughter of cows, Lordship. There's the illusion, but the seizure, Lordship, no,
Okay,
beef was recovered, nothing, Lordship.
Yes.
And not caught red-handed. Lordship, because the allegation he is running a illegal slaughterhouse, Lordship. From there, Lordship, the recovery has been made, various cutting wool and Lordship one horn, cow horn has also been recovered. But
Okay,
this is-
heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Imran Ali, who has been detained behind the bars since 27/8/2025, within bracket for last 19 days in connection with DFU PS case number 73/2025 under section 61 within bracket 2 within bracket A /299/196 within bracket 1 of BNS 2023, read with section 13 within bracket 1 of Assam Cattle Reservation Act. The gist of accusation in this case is that on 27/8/2025, one Ritupal Senchua, former SI of police, had lodged an FIR before the officer in charge of Depot Police Station, inter alia, alleging that on the
Hard copy is
basis
there, wait.
Huh?
Hard copy is there, Lordship, page 8.
on the basis of a information received through reliable sources regarding illegal cow slaughtering, the informant along with the police team raided the house of the petitioner. Stop. During the search operation, an illegal slaughterhouse was found along with sharp weapons, knives, and other material used for slaughtering of the cows. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 19 days and considering the nature of accusation made against him, the period of detention may be considered sufficient to investigate the offense alleged against him. On the other hand, learned additional public prosecutor has produced the case diary of DFU PS case number 73/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary. I have considered the submissions made by learned counsel for the petitioners, counsel for both the sides, as well as peruse the case diary of DFU PS case number 73/2025. Though there are incriminating materials against the petitioner in the case diary, however, considering the progress made in the investigation as well as period of detention undergone by the petitioner, this court is of considered opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation of the aforesaid case if the petitioner continues to cooperate in the investigation. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate DFU, Chief Judicial Magistrate Karbi Anglong Kumar DFU, with following conditions, number 1 and number 2. Send back the case diary. His bail application is accordingly disposed.
Much obliged. Much.
58 months supplementary list. Item number 58.
None.
The petitioner was arrested on the strength of one offense report. What we find at page.
Special public prosecutor, you have to, you inform him, Mr. D. Gogoi, let him appear. We'll take up. If he comes earlier, we can take it up earlier also. As soon as he comes, we'll take it.
Item 61.
May I please, Your Lordship, kindly pass over this matter for the time being. My senior is lying in another.
Notice was issued, because after perusal of the case diary, it came to your Lordship's attention that notices were not issued probably.
Notice has been served.
No, Lordship, it was very recently, it was on 10/9 probably, Lordship, I am not sure. Lordship.
Case diary is there.
Yes.
Kindly pass over the. For the time.
We'll appoint one amicus. Oh, MS Laskar is there. Inform the amicus. Let him come. Let Mr. Laskar also come. We'll take it up after some time.
Item 30.
Lordship may kindly pass over the matter for time being, Your Lordship.
You are on interim.
Yes, Sir, Lordship.
Case diary is there. He has appeared.
Yes, definitely.
We will dispose it of.
Otherwise, materials are there, and but he has.
Heard, Mr. What is your name?
A Thakuria.
Heard, Mr. A. Thakuria, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that how many petitioners are there? The petitioner, namely Jari Lal Sharma, was allowed to go on interim bail by order dated 2/6/2025 by this court. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Dulyajan PS case number 64/2025 and has submitted that there are incriminating materials against the petitioner in the case diary. However, he also submits that the petitioner has appeared before the investigating officer and his statement has been recorded under section 180 of BNSS. So I have considered the submissions made by learned counsel for both sides and have gone through the case diary. So, since the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him on 2/6/2025 by this court is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed.
Highly obliged.
I communicated supplementary number 58. I communicated and Gogoi stated that he is not keeping well, but the CD will be furnished by one of the fellow colleagues at 2.
Okay, we'll take it up at 2.
Everyone.
May please, Your Lordship. Lordship, report was called for.
Charge sheet submitted.
Yeah, sheet submitted. Heard Mr. What is your name? M. Rahman.
N. Ahmed.
And
Islam.
Yeah.
Islam.
heard Mr. Islam. What is your name?
Imdadul Islam. Islam, Lordship.
Heard Mr. Islam. Learned counsel for the petitioner. Also heard Mr. You have appeared before the investigating officer? Yes or no? Okay.
You don't know.
You have to know. You take instruction. We'll take it up after some time. Take instructions whether have you appeared before investigating officer or not.
Yes, Lord.
You find out and then make submissions.
Okay.
Item 32.
May please, Your Lordship. This is a 430, this is an application for anticipatory bail, Lordship. Lordship would find the FIR page number 11, Lordship.
In this case, I am engaged with legal counsel. Not to submit the copy.
Proxometer. You have not served the copies that was directed.
Last occasion, actually, we have missed the item,
Last
Lordship.
occasion, she was not present.
Yes, Lordship. That is probably the reason why.
This is liable to be dismissed for
Lordship,
not complying with the directions of this court.
I'll serve a copy.
Heard Mr. P. Deka, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, as well as Mr. K. M. Haloi, learned legal aid counsel appearing for respondent number 2, who submits that he has not yet received the copies of bail application along with annexures from the petitioner. On this, learned counsel for the petitioner submits that he shall furnish the copies of the bail application along with annexures during the course of the day. Stop. In view of this, when can we fix it?
Any day, this week, any day, Lordship. I will serve him to the right now. itself.
24th.
It is interim order, Lordship.
Let this case be listed again, again on 22nd of September. The interim order shall continue till next date.
Highly appreciate.
Ordered item 44.
Maybe please. Your Lordship, this criminal appeal was filed in the month of August 2024, and the IA is pending for the TCR was called for, that has been received. And the accused is languishing in jail total for 577 days for the offense only of 365. Initially, it was registered and serves for POXO as well as 366A. And the court doesn't find any materials under POXO, that is REP, and 366A. But court has convicted the accused under section 365 of the IPC and awarded maximum punishment of 7 years and as well as fine of 30,000 ID of FI for 6 months. So he is behind the bar total for 577 days. Lordship,
But that is after conviction.
yes, no, total. Lordship, he is now 422 days and earlier he was 155 days, total 577 days. Lordship, more than 19 months.
Now, what is your submission?
Yes, Lordship. My submission is that, Lordship, here in this case, as per the statement of the victim, initially the victim was taken by one Rafiqul from her house. So that Rafiqul is absconding. So trial is only against me. So the and here in this case, there are two 164 statements. Two 164 statement was recorded. One is on 16/7/2018, and another is after 23 days. That is on 8/8/2018. So in the second subsequent 164 statement, she has developed the case. Therefore, learned court in Lordship in the main memo of appeal in page number 54-55, Lordship. Para 54-55.
Okay.
Lordship, para 54-55. It was clearly stated by the trial judge that from the aforesaid circumstances, that keeping in mind the fact that there was the army camp. So, Lordship, 55.
Page number?
Page 54. In view of all.
An additional public prosecutor has submitted that the petitioner, that though there are materials on record to before the trial court to serve out the sentence imposed on him by the impugned judgment, this criminal appeal, this interlocutory application is accordingly disposed of. Let in criminal appeal, let this criminal appeal, not so and so, let this criminal appeal be listed for hearing in its usual course.
45.
Yes.
All of this matter has been come for orders. Already you have took the service matter upon the respondent number matter, but the service report is awaited, man.
This is a POXO matter or 125. What should we do?
35.
No, what is your submission?
My lord, this matter, I have basically challenging the.
No. Will you take fresh steps or should we await?
I will take the press step, man.
Heard Mr. What is your name?
Yes, sir.
Heard Mr. S. Sharma, learned counsel for the petitioner. It appears from the office note. Office note dated 10/9/2025 that neither the AD card nor the unserved notice in respect of notices issued to the sole respondent have been received back by the registry. Stop. In view of this same, the petitioner is directed to take fresh steps for service of notice on the sole respondent by way of registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after.
My lord, I have also a humble prayer, my lord. Say this honorable learned trial court below has give direction to pay the monthly allowance to the extent of rupees 9,000, my lord. And the arrear salary also, and the arrear amount also be paid within 6 months from the date of the filing of this case, my lord. So my humble prayer before your lordship, I may be allowed only to pay the 9,000 rupees to the extent of 9,000 rupees.
No,
To wife, my lord.
no stay now without due service of notice. Only after due service of notice, any interim relief may be considered.
That observation may be required.
The prayer for interim relief made by the petitioner shall be considered only after due service of notice on the sole respondent. Please accordingly.
Leave them.
46.
May it please the lordship. Lordship, in the statutory appeal, the petitioner has been convicted under section 21B of NDPS Act. He has been sentenced for a period of 5 years and a fine of rupees 30,000 in default 3 months extra simple imprisonment, my lord. An appeal has been admitted, my lord, and the petitioner is a woman. She has been behind the bar since the date of the judgment. As on today, she has been behind the bar for the last 189 days, my lord.
Many days?
189, my lord.
189.
Excluding the 60 days, he was also in the jail during the investigation period for 60 days, my lord.
Excluding those 60 days.
From the date of judgment, he has been behind the bar for
249 days.
my lord.
What are your grounds?
My lord, I have cited in the appeal, my lord. There are 7 witnesses, prosecution witnesses. My argument in the appeal is that the contraband allegedly governed not the conscious position of the appellant, my lord. And as well as the secret information required to be written down under section 42 of the
Yes.
NDPS Act has not been done, my lord. The clear procedural lapses in a part of the prosecution, my lord.
Service not completed, not answer.
Service on whom?
Activities on order dated 15/7/2025.
PW1, he is a official, police officer, my lord.
Why he has been made a party? Why you made informant as a party?
My lord. Procedure something is.
Where is that procedure? That in NDPS case you have to
Yes, my lord.
made in.
Correct, my
You
lord.
have yourself made the process cumbersome.
My lord.
Moreover, Lordship, in the order dated 15/7/2025, it has been stated by the coordinate bench, Lordship. Till the appearance of respondent number 2, this petition will not be considered.
On merit, my lord. Stated. Supervision.
No, why you have made party?
My lord.
There is no such requirement.
Not on merit, my lord.
No, is there any such requirement of Yes,
Otherwise, it is not required, but what allegation we have alleged on the SI, it depends on that, Lordship. Is there any specific allegation apart from lodging an FIR? If there is any other allegation that he has done something, then Lordship.
and respondent number 2 is IO.
Yes, my lord.
Why you have, now what is to be done? You wait for till service of notice.
Well, he is the informant in this case, my lord.
No, when you have made him a party, you wait till service of notice.
My lord, we have been behind the bar on merit, my lord, for the last more than 200 days.
No, but we have to follow the procedure.
It's a police officer, my lord. He is presently in Lakhimpur district, my lord. He does not know that service is not served, my lord. Presently
You
in
take
charge-
fresh steps, though it is not required.
It will be hard on merit, my lord.
Hard.
May be considered, my lord.
Third, Mr.
Yes, Google, my lord.
S. Gogoi, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 430 of BNSS 2023 has been filed by the petitioner, namely Muhammad Josna Begum alias Jyotsna Begum, who is praying for suspension of sentence imposed on her by the judgment and order dated 10/3/2025, passed by learned Special Judge Lakhimpur, North Lakhimpur in Special NDPS case number 5/2022. How much was the contraband?
Intermediate 12.05, my lord.
Heroin,
Intermediate one here in my lord. But that was not.
5/2022,
This is a
whereby the petitioner was convicted under section 21B of the NDPS Act 1985 and was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 30,000, and in default of payment of fine to undergo simple imprisonment for 3 years, 3 months. So, learned counsel for the petitioner has submitted that the petitioner has impugned the aforesaid judgment by filing a connected criminal appeal number 228/2025. Stop. He submits that as the seized contraband was not found from the conscious possession of the present petitioner, he is hopeful of getting a favorable result in the connected criminal appeal filed by her. Learned counsel for the petitioner has, however, submitted that as the sentence imposed on the petitioner is of imprisonment for 5 years only, which may be regarded as a sentence of short-term imprisonment. He may be allowed to go on bail after suspending the execution of the sentence imposed on him. As otherwise, the purpose of filing the criminal appeal by the petitioner may become infructuous. On the other hand, learned additional public prosecutor has submitted that In this case, notice on the respondent number 2 has not yet been served. On merit, materials are there.
I have not gone to the law, voluminous lordship.
Only 7 witness matter in this case. Only 7 witness matter, including the IO, MO and FHL.
You have any submission on? Otherwise, we are allowing.
Lordship. Otherwise, lordship. It is a convicted,
He also submits that the petitioner has been rightly convicted by the trial court on the basis of the materials against him on the basis of the evidence collected against him, evidence adduced against him during the trial. Stop. I have considered the submissions made by learned counsel for both sides. Since the investigating officer has been made as a respondent in this case, and there is no such legal requirement of making the investigating officer a party in a application under section 430 of BNSS. Notice to said respondent is waived. Stop. Learned. It also appears that the sentence imposed on the petitioner is for a period of 5 years only, and she has already been detained behind the bars for last 280. This calculation, you are right.
118 days for the date of judgment, my lord, and other 60 days during the investigation period.
And for 289 days.
No, my lord, 254 days, my lord.
254 days. Yeah. Hence, considering the sentence imposed on the petitioner to be a short-term sentence of 5 years, and also considering the number of criminal appeals pending before this court is inclined to suspend the execution of sentence imposed on the petitioner by invoking its powers under section 430 of BNSS. Stop. Accordingly, the sentence imposed on the petitioner by the impugned judgment is hereby suspended during the pendency of the connected criminal appeal number 228/225. The petitioner is also allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Special Judge Lakhimpur, North Lakhimpur, with a condition that in event of dismissal of the connected criminal appeal number 228/2025, the petitioner shall surrender before the trial court to serve out the remaining part of the sentence imposed on her by the impugned judgment. This interlocutory application is accordingly disposed of. In main criminal appeal, heard both sides. Heard both sides. See. নাম দিব উকিলৰ। In main appeal also you have made investigating officer as a party. Yes. Yes or no?
Yes, my lord.
It appears that the investigating officer of the case has been made as a respondent in this criminal appeal. And as there is no such legal requirement of making investigating officer a party in the criminal appeal, the name of the said respondent is struck out from the memo of appeal. It also appears that the trial court records have been received. Let this case be accordingly listed for hearing in its due course. No, listed for hearing after 8 weeks. After 8 weeks from the date of this order. Yes.
My lord, there is a NI, my lord. Both the parties have been amicably settled, my lord. He is in behind the glass for the last 142 days.
Atul, Baki record. Which IA you have filed?
My lord. I have for continuation of delay, my lord. Actually, I have two, I have been filed. In the meantime, my lord, both the parties have been amicably settled, my lord.
Okay. You have no objection.
No objection, Lordship, already the amount has been paid, Lord.
Heard. Mr. S. Gogoi, learned counsel for the petitioner. Also heard Mr.
Yes, yes, Honor.
S. J. Sharma, learned additional, learned counsel for the respondent.
Number 2.
Respondent number?
2.
2, as well as Ms. N. Das, appearing for learned additional public prosecutor, appearing for the respondent number 1. This interlocutory application has been filed under Section 5 of the Limitation Act, praying for condoning the delay of 57 days in filing the connected criminal revision petition, whereby the petitioner has impugned the judgment and order dated 25/2/2025 passed by the Court of London, Judicial Magistrate First Class in NI case number 4/2021, whereby the petitioner was convicted, petitioner has been convicted under Section 138 of NI Act and has been sentenced to simple imprisonment for 6 months and to pay a fine of rupees 5,30,000, and in default of payment of fine to undergo simple imprisonment for 1 month. Learned counsel for the respondent number 2 has submitted that since the matter has been amicably settled between the parties, the respondent number 2 does not have any objection in condonation of the delay. Does not have any objection if this court condones the delay of 57 days, file 57 days in preferring the connected revision petition. So I have considered the submissions made by learned counsel for both sides. Considering the submissions of learned counsel for the parties, as well as considering the grounds shown in the delay condonation petition for approaching this court belatedly after a delay of 57 days. This court is of considered opinion that the said delay has been sufficiently explained by the petitioner, and accordingly, the delay of 57 days in filing the connected criminal revision petition is hereby condoned. The registry is directed to register the connected criminal revision petition and list the same for admission day after tomorrow.
We will give another 132 days scheduled to the meeting.
On 17. Today,
132 days, well,
21.
21 days.
day after tomorrow. List this matter. List the same on 17 September 2025. This interlocutory application is accordingly disposed of.
Deeply obliged.
All right.
Lordship, I beg the Lordship, apology, Lordship. I need to show one thing, Lordship. In 36 item, there is a bar of no suspension should be there, Lordship.
No, only in only when it is barred by 37,
Lordship.
only in commercial quantity cases,
Not in the.
not in intermediate quantity. That in commercial quantity also, there is a judgment of Apex Court, Dadu,
Lordship.
which says that the bar is not an absolute bar.
Much obliged.
Item 41. Item 61.
Lordship, I beg apology when the item was called Lordship, leg in court, another court, Lordship. Here, Lordship, regular bail application, Lordship, statutory period is 60 days. Today, Lordship, I am on 59 days, Lordship. Lordship probably remember the Lordship that AI generated photo, Lordship.
Where the photo was edited and the face of the victim girl was pasted on a other photo.
So you are behind the bars for AI.
AI.
And Lordship, they have circulated, all these persons, they have circulated the photograph, Lordship, that is the.
Now, what is the progress of the investigation?
Already, Lordship, mobile phone has been seized and it has been sent for FSL. Lordship.
Yes, Mr. Laskar, you have anything to say?
Allegations are no doubt serious because in the present context, if a photo is being taken and AI modified and then pornographic, it made pornographic and sent to other, it is a very serious and needs to be dealt with a very high hand in this present day. But in this case, your Lordship, what I find that even they have also admitted that the photos has been edited, but their case is that they have not done it. It has been done by some persons from Hyderabad. So far the basic allegation that there is an a photo was edited, it has been circulated. It is even they are also admitting, your Lordship. This, your Lordship.
They have circulated.
They have said that it has been done by some other persons. They are in the group, they have not circulated it. But the fact that it is edited, they have also admitted that these are edited photographs with the help of AI at paragraph 5, your Lordship. They have admitted it.
Heard Mr. B. Chaudhary, learned counsel for the, what is the punishment?
Punishment is Lordship below 7 years, Lordship, 5 years here, Lordship. First offense, 5 years, Lordship, 14A.
Also heard Mr. B. Sharma, learned additional public prosecutor,
14-1, Lordship.
as well as Mr. M. H. Laskar, learned amicus curiae appearing for respondent number 2. This application under section 483 of BNSS has been filed by the petitioners, namely Apurva Kumar Das, Amar Jyoti Das, and Pranjal Das, who are detained behind the bars in connection with Panigaon PS case number 46/2025 under section 14 within bracket 1 of POXO Act 2012, read with section 67 within bracket A 67A of the Information Technology Act. The gist of accusation in this case is that where is the FIR?
On page 20, Lordship, relevant portion.
That on 18/7/2025, the victim girl the mother of the victim girl had lodged an FIR before the officer in charge of Panigaon Police Station, naming 7 accused persons in the FIR, including the present petitioners, inter alia alleging that the accused persons have, by using AI techniques, have already completed 59 days. And therefore, I praise for allowing the petitioners to go on bail. On the other hand, Mr. B. Sharma, learned additional public prosecutor, has produced the case diary of Panigaon PS case number 46/2025 and has submitted that there are sufficient incriminating materials against the petitioners on record of having circulated the morphed photographs of the victim girl in social media. He, however, submits that the investigation has fairly progressed. Mr. M.H. Laskar, learned amicus curiae, appearing for respondent number 2, has also submitted that the accusation made against the petitioner are grave in nature. However, he also submits that the fact that the petitioners are already behind the bars for last 59 days may go in their favor. So considering the submissions made by learned counsel for the parties, as well as considering the progress in the investigation and period of detention already undergone by the petitioners within 59 days, this court is of considered opinion that if they cooperate in the investigation, their further custodial interrogation may not be necessary for fair completion of the investigation of Panigaon PS case number 46/2025. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned
Special Judge Poxo, Lakhimpur, North Lakhimpur.
Special Judge Poxo, Lakhimpur, North Lakhimpur, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed.
Obliged.
31.
You're on interim? No.
Interim lordship. The petition appeared before the IO lordship on 27th July. Lordship.
What was the date of interim order?
Lordship, the order dated lordship 24/7 interim order.
Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court by its order dated 24/7/2025. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer on
27
27
7/2025.
7/2025 and has cooperated in the investigation. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
433/25 dated 29/7/25.
stop. Considering the fact that charge sheet has been submitted and also considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the petitioner Kasim Ali on 24/7/2025 is hereby made absolute, subject to the condition that he shall cooperate in the trial. This anticipatory bail application is accordingly disposed of.
48. Deplorable.
Yes.
Lordship, the criminal petition has been filed under section 528. I am for the complainant. I have filed an IA for vacation of the stay order. Lordship, it's a very small matter. It may take up for final disposal of the, if Lordship pleases. Because they have. Entire
Yes,
case.
my lord, that will be better.
Because the facts are very limited and it's only to the aspect that whether the civil dispute, whether a civil case or in a civil dispute, whether criminal the case is made out or not. Here I have to satisfy Lordship that the from the complaint itself, which are the sections which are applicable, this has to be made out. So Lordship, if is inclined to take up the for final disposal, then he may start with his argument and then I might reply.
No, then, my lord, today I am prepared only for the IA, my lord. Then after
Because
vacation,
ultimately
We'll fix a short date.
Lordship,
Lordship.
Lordship.
Mr.
RJ Das for the applicant.
I am for a D Bola.
Heard Mr. D.
Petitioner.
Borwa, learned counsel for the
Petitioner.
petitioner and opposite party in the interlocutory application. Also heard Mr.
RJ Das.
RJ Das, learned counsel for the sole, learned counsel for the respondent as well as applicant in the interlocutory application. It is submitted at bar that this matter may be heard for may be heard for final disposal instead of deciding the interlocutory application. The prayer is allowed. Let this matter be listed for when 16th October.
Lordship.
Let this matter be
17, Lordship. 17 maybe.
No, Thursday is a better, would be a better
Thursday,
hearing.
yes, yes, 16,
16th
16,
October
15 also, no?
for final hearing.
In the meantime, the
Deeply
interim may be
obliged.
continued.
In the meanwhile, the interim order shall continue till next day.
Oblige.
Deeply obliged.
49.
Matter may be listed for admission.
Admission hearing. Lordship.
We are admitted.
No, it is not.
Full hearing.
May I please your lordship, the CBI counsel had to leave because she was not feeling well. So can the matter may be taken up tomorrow?
Lordship,
What is the matter?
Lordship, an IA has been filed, Lordship, the bail application, Lordship, certain conditions were given, Lordship, challenging those conditions, Lordship. To modify the bail condition, Lordship. Lordship, this matter is led by Mr. D. Saika, Lordship. Lordship, tomorrow we have some difficulty, Lordship, Friday, Lordship, if possible.
Lordship, Friday she'll be out of station.
You mutually agree upon the date.
Monday, Lordship.
When can it be fixed?
Lordship will inform the court master. Then, Lordship.
Heard Miss P. Borwa, learned counsel for the, this is item number?
39, Lordship.
Learned counsel for the applicant. Also heard Miss
N. Chaudhary.
N.
Chaudhary.
N. Chaudhary, learned counsel, appearing on behalf of learned standing counsel, CBI, who submits that the standing counsel, CBI, had had to leave the court early due to some health issues. And on that ground, he has prayed for an adjournment. Learned counsel for the petitioner has not objected to the prayer considering the grounds submitted by the grounds shown by the learned counsel for the petitioner. Let this case be listed when
Friday, Lordship, this Friday, but they have some difficulty, Lordship. Within this week, Lordship, but we'll discuss. And
Friday is okay.
Ship, she'll be out of station.
When she will be?
On Friday, she'll be out of station.
Thursday?
Lordship, I have to ask my senior Lordship regarding the date, Lordship.
Next week.
From the court master, Lordship, the specific date, Lordship. if possible.
Okay, you both of you inform the court master later. Let this matter be listed in the next week on a date to be fixed by registry. You request the registry.
Lordship, we have urgency in that case, Lordship. Then Lordship may give me, Lordship, I'll inform the court master.
Inform the court master.
Pleasure. May I please, your lordship? Lordship, item number 42, I am not feeling well, my lord, so I want to go home. That's why only 12 and 9 days delay, my lord, to file the criminal. 42 fever, my lord.
We'll take it up after some time. We will adjourn the matter, item number 40.
Day after tomorrow, my lord.
We'll adjourn it. 42 mark kore rakhi. Pune order is set aside and matter is remanded back to Railway Claims Tribunal with a direction to decide the case afresh after affording opportunity to both the parties to adduce evidence in support of their case. Keeping in mind the provisions contained in Section 65 of the Railways Act 1918. For reasons mentioned in the judgment, both these regular second appeal are hereby dismissed.
Item 53.
For reasons mentioned in the for reasons mentioned in the judgment, this review application is allowed and the impugn order passed in IA number 974/2020 is hereby set aside. Consequently, the regular second appeal number 150/2017 is restored to file. Registry is directed to list the RSA for admission hearing. For hearing, sorry.
For hearing. All right.
For reasons mentioned in this judgment, the MFA number, the appeal preferred by National Insurance Company is hereby dismissed.
Obliged.
Item 52, item 58.
Yes.
I communicated the special people.
Well, I am with you.
Yes, what is your case?
On the strength of one preliminary offense report.
Since when you are behind the
Arrested-
bars?
Arrested on 07/08/2025,
How many days?
40 days. And also the section involved will also. Section 24, 25, 40 and 41 of Assam Forest Regulation 1891 amended on.
Yes, do you need his custodial
No, my
interrogation?
lord, my length of detention may be considered.
Okay. Heard, Mr. This is item number?
58, Your Lord, 50, supplementary.
Heard, Mr. R.P. Hajurika, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned special public prosecutor wildlife. This bail, this application under section 483 of BNSS 2023 has been filed by the petitioner, namely Nikumani Rajbanshi, who has been detained behind the bars since 7/8/2025, within bracket for last 40 days in connection with offense report number KR/03 of 2025-2026, dated 7/8/2025, under section 2425 40/41 of Assam Forest Regulation 1891. The gist of accusation in this case is that on 8/8/2025, on 7/8/2025, the range forest officer, Kurwa Range Forest, Bagora, had found 4 numbers of teak stumps indicating the recent felling of teak trees, and in order to find out the miscreants involved in the felling of teak trees, a search was conducted. And during search, it was found that the petitioner, along with some other persons, were involved in the act of felling teak trees. Accordingly, the petitioner was arrested on 7/8/2025. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged against him. He further submits that the petitioner is languishing behind the bars for last 40 days, and considering the nature of offense alleged against him, the period of detention already undergone is sufficient for the purpose of investigation. Learned special public prosecutor wildlife has also submitted that the investigation has fairly progressed and offense report has been filed.
My lord, no, this is my lord, final offense report not filed, my lord. Investigation is on, my lord.
Fairly progressed, and considering the period of detention, you have no objection.
My lord, considering the
of
length of detention, my lord, that
Considering the length of detention, he does not have anything to say regarding the prayer for bail application, prayer for bail made by the petitioner. Considering the submissions made by learned counsel for the petitioner, learned counsel for both sides, as well as progress in investigation, as well as the period of detention already undergone by the petitioner. This court is of considered view that if the petitioner cooperates in the investigating authority, his further custodial interrogation may not be necessary for fair completion of the investigation. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of session judge.
My lord.
Session judge,
Chief Judicial Magistrate Dorong.
Learned Chief Judicial Magistrate Dorong, Nongoldai, with following conditions. Number 1 and number 2. This bail application is accordingly disposed of.
Apply to. Item 40.
Yeah, please, my lord. My lord, this is IA, my lord. IA for confirmation of delay, my lord. It's 17 days, my lord. My lord, sole respondent, my lord, at this stage notice may be issued, my lord.
Item number 40. Third, Mr. A. Datta, learned counsel for the petitioner. This interlocutory application has been filed by the petitioner, namely Diganta Bora, praying for condonation of delay of 17 days in preferring the connected criminal revision petition. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days, 3 days, within 3 days from the date of this order, returnable after 3 weeks, 4 weeks,
3 weeks,
3 weeks, list accordingly.
Deeply obliged.
Item 41.
May it please your lordship. In this matter, lordship, I am appearing as legal aid counsel, lordship. And there is an IA for condonation of delay of 50 days only, lordship. And the case is of conviction is 326 and 307, only 5 years. So at this stage, lordship, if the learned prosecution has no objection, then I pray to condone the delay and direction will be.
Yes. Do you have any?
Otherwise, this is statutory appeal, lordship, if satisfied, lordship.
Heard Miss N. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This interlocutory application has been filed under Section 5 of the Limitation Act by the petitioner Rabindranath, Shri Rabindra Bishwas, who is serving out his sentence imposed on him by the judgment and order dated 30/4/2025 passed by the learned session judge Borpeta in sessions case number 151 of 2024, whereby the petitioner was convicted under section 326 of Indian Penal Code and was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 3,000 and in default to undergo rigorous imprisonment for further 1 month. The petitioner was also convicted under section 307 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 3,000 and in default to undergo further rigorous imprisonment for 1 month. Both the sentences are directed to run concurrently. The petitioner has impugned the aforesaid judgment by preferring the connected criminal appeal, and there is a delay of 50 days in preferring the said appeal. So, learned counsel for the petitioner, learned legal aid counsel has been, learned legal aid counsel Ms. M. Chaudhary has submitted that the cause of delay in preferring the connected criminal appeal has been stated in paragraph number
Paragraph, 8, paragraph 8.
paragraph number 8 of the condonation, paragraph number 8 of the application for condonation of the delay. The stop. Learned additional public prosecutor, considering the grounds stated in the condonation of delay application, as well as considering the fact that the applicant is defended in this case by legal aid counsel does not raise any objection against the prayer for condoning the delay. I have considered the submissions made by learned counsel for both sides. Considering the submissions made by learned counsel for both sides, as well as grounds stated in paragraph number 8, whereby the petitioner has stated the cause for approaching this court by preferring the connected criminal petition belatedly. Stop. This court is of considered opinion that the ground shown are sufficient grounds which prevented the petitioner to approach this court within the prescribed period of limitation for filing the connected criminal appeal. The said delay of 50 days is therefore condoned. The registry is directed to register the connected criminal appeal and list the same for admission. This interlocutory application is accordingly disposed of.
So filed one bail application.
Let it come. Because once appeal is registered, your interlocutory application would have to be registered.
42.
I agree with the lordship. My lord, considering the party's interest, as I am appearing as legal aid counsel, my lord. So I am waiting for this matter, my lord.
You are also appearing for
Appeal and my lord, only 1209 days delay, my lord, to file the criminal appeal, my lord.
what is the offense?
My lord, convicted under section 4 of the POCSO Act, my lord, 7 years
Also, then
punishment.
notice have
Notice
to,
has to go.
if it is
Notice like
heard.
PB board.
Ms. P.B. Bordole, learned legal aid counsel, appearing for the applicant. This interlocutory application under section 5 of the Limitation Act has been filed by the petitioner, by the applicant Pintu Burman, praying for condoning the delay of 1, 2, 09 days in filing the connected criminal appeal, whereby the petitioner has impugned the judgment and sentence, judgment dated 31/5/2023, passed by the Court of Learned Additional Session Judge from Special Judge POCSO, whereby the petitioner was convicted under, you are convicted under Section 4 of the POCSO Act 2012 and was sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 15,000, and in default of payment of fine to undergo simple imprisonment for 6 months. Since in this case, offense under POCSO Act is involved, let the notice be issued to respondent number 2/informant in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 7 days from the date of this order, returnable on 22nd October.
Highly obliged.
List according.
Yeah, please, your lordship. I for continuation of delay, lordship, delay of 234 days.
POCSO case, lordship, this one.
POCSO.
Lordship.
Heard Miss
R. Shaheen.
R. Shaheen, learned. Your engaged counsel,
Lordship.
learned counsel for the applicant. This interlocutory application has been filed under Section 5 of the Limitation Act for condoning the delay of 234 days in preferring the connected criminal appeal by the applicant Musammat Anwara Begum. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 in pursuant to within 7 days from the date of this order, returnable after 3 weeks. List accordingly.
44.
May it please your lordship. Lordship, the IA before your lordship is a petition for condonation of delay of 100 days, lordship, in preparing the appeal, lordship. And I am appearing as a legal aid counsel for the petitioner, lordship.
What is the offense?
Offense under section 20B2 Roman C of NDPS Act.
What is the
I
punishment?
have explained
Punishment?
10 years.
Will you file any objection?
Delay is there, lordship. Otherwise, lordship, secretary.
There is a official, due to some official
Secretary
communication,
appeal.
lordship, delay has occurred.
Heard Mr. B. Halder, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under Section 5 of the Limitation Act has been filed by the petitioner. Manawar.
File. Section, lordship.
No, you not necessary to file. If you think that it, considering the offense, you may file. You will be filing.
Lordship. Hey, NDP.
You did not to file because I have.
Lordship.
Will you file or not?
No, Lord. No, Lord.
क्या लिखा? Limitation Act, praying for condoning the delay of 100 days in preferring the connected criminal appeal. Stop. By preferring the said appeal the petitioner has impugned the judgment and order dated 3/10/2024 passed by learned Special Judge Karimganj in NDPS case number 90/2022, whereby the petitioner was convicted under section 20B2C of NDPS Act 1985 and was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh, and in default of payment of fine to undergo further imprisonment for 1 year. Learned counsel, where is the explanation?
Paragraph number 5 and 6, Lordship, of the petition.
Learned counsel for
Page 4
the,
and 5.
learned legal aid counsel for the petitioner has submitted that the delay was caused as the petitioner has been afforded the legal aid in the form of appointing a legal aid counsel for filing of the said appeal, and the reasons for delay has been stated in paragraph number 5 and 6 of the application for condonation of delay. Learned additional public prosecutor, on the other hand, submits that considering the fact that in this case legal aid counsel has been appointed, the state does not intend to oppose the prayer for condonation of delay. I have considered the submissions made by learned counsel for both sides and have gone through the records. Considering the submissions made by learned counsel for the parties, as well as considering the grounds for delay shown by the petitioner in paragraph number 5 and 6 of the application for condonation of delay, this court is of considered opinion that the cause for approaching this court approaching this court by filing the connected criminal appeal belatedly with a delay of 100 days has been sufficiently explained in the application for condonation of delay. Stop. The said period of 100 days of delay is therefore condoned, and this interlocutory application is allowed. Registry is directed to list the connected criminal appeal for registry is directed to register the connected criminal appeal jail and list the same for admission on a date to be fixed by it. This interlocutory application is accordingly disposed of.
45.
Lordship, I raise condonation of delay of 118 days, Lordship.
What is the offense?
Criminal revision petition, Lordship. Lordship, judgment was passed on 12/12/2024, Lordship. What if not? Notice may be issued, Lordship.
Heard, Miss, what is your name?
Are they, Lordship?
Are they learned counsel for the petitioner? Also heard Mr. KK, also heard Miss N. Das, learned additional public prosecutor. This application under section 5 of the Limitation Act 1963 has been preferred by the petitioner Durgeshwar Nath for condonation of delay of 118 days in preferring the connected criminal revision petition. Let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by a registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
46. May I please your lordship? Lordship, in this case, what happened, lordship? I am preparing this appeal against the revision, lordship. This revision is against the appeal by modifying that conviction of 4 lakh rupees fine and the 4 months in default. What happened, lordship, in the session court in a negotiable instrument act case?
For what purpose this IA is there?
IA, there are 2 IA. One is for condonation of delay and one is for bail by suspending. But in the meantime, lordship, on last 8 August, the warrant was executed and I was put behind the bar. So I am praying that notice may go, and in the meantime, lordship, I may be allowed to go on bail. Otherwise, that main revision would be infructuous. Because 4 months, lordship, in default of simple imprisonment has been given.
We'll fix a short date. Because unless your delay is condoned,
That is correct, but lordship, I am not saying, lordship. What happened, lordship? If lordship can condone the delay, then in the interim also I may be allowed to go on bail. Otherwise, only 4 months in default. Already 45 days. I
now
am behind the
suppose
bar.
delay is not condoned.
But then I will again go to behind the bar. If lordship notice would be served, it will come back, then entire sentence period would be covered, lordship. There would be either, I am ready to pay that amount, lordship. Already 1 lakh has been paid.
Heard Mr.
PP.
P.P. Datta, learned counsel for the petitioner. Also heard Miss Enda's, any state is, you have made state
Yes.
apart.
Yes.
Miss Enda's, learned counsel for learned additional public prosecutor appearing for respondent number 1. This application under section 5 of the Limitation Act 1961, 1963. Limitation Act is 1961 or 3.
1960. Limitation of funds.
You have mentioned it wrongly in your,
Lordship, sorry, the 1960
it is 63.
limitation.
There is a typographical error. For condoning the delay of 364 days in preferring a revision, in preferring the connected revision petition, whereby the petitioner intend to impugn the judgment and order dated 7/6/2024, passed in criminal appeal number 36 within bracket 4/2023 by the learned session judge, not Lakhimpur. Issue notice to the respondent number 1. Respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by a registered post with AD as well as by usual mode within 7 days from the date of this order. At a date of sorry opt out. Let this case be listed again on 22nd of October. Next. The question is, unless you have preferred interlocutory application in the criminal revision application.
That is yet to be numbered, lordship.
Interlocutory application is also yet to be numbered.
Yes, I
Then
understand.
how relief can be granted? Had you prefer?
Lordship.
You have not paid for relief in this delay condonation application.
In
Unless it is registered,
lordship, I
It
understand,
cannot be
lordship,
taken
that
up.
point.
we'll fix a short date.
Lordship.
Within 3 days from the date of this order, returnable on 26th.
Fix the matter on next week.
Within in the meter, I will try to get the served with Dusty Lordship. Or otherwise, Lordship, delay condonation is a discretion of the court. Otherwise, Lordship. Obviously, Lordship, opposite party must be heard.
He has a right to be heard.
In the opposite party, but it is not a reviewed rule also. If Lordship satisfied,
You find out what can be done. We are fixing it on 26th.
Lordship.
तो लिखे the I 998. The petitioner shall take steps for issuance of notice upon the respondent. Number 2, through the officer in charge of jurisdictional police station within 3 days from the date of this order. Through the registry of this court, through the officer in charge of jurisdictional police station, the said notice shall be routed through the registry of this court. The officer in charge of jurisdictional police station is directed to serve the notice on the sole respondent and send a service report to this court through the registry of this court so that it reaches this court before next date fixed, that is 26/9/2025.
let it be 25.
25/9
is the last date.
25/9/2025.
Upon respond number 2.
Yes, upon respondent number 2. Anything, Abhishek?
Obliged. I also searched yesterday, make a search, but I could not find any authority in this regard that without condonation of delay. But in civil matter, Lordship, there is a judgment of our High Court that even without condonation of the delay, the stay of that execution was stayed in one matter. But in criminal, Lordship, there is no
Stay will be passed in which case?
that in
It has to be passed in the condonation of delay
Condonation
application itself.
Yes,
Now you find out whether this can be done or not.
that's it.
On the next date,
That's it.
26.
That's it.
Delay of 988 days against the ex parte order. Notice from your lordship.
Heard Mr. M. Datta, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor appearing for respondent number 1. This application under section 5 of the Limitation Act has been filed by the petitioner, namely Tuntun Bora, praying for condonation of delay of 988 days in preferring the connected criminal revision petition, whereby the petitioner intend to impugn the ex parte judgment and order dated 12/9/2022 passed by London Judicial Magistrate First Class Sonitpur Tejpur in MR case number 18/2022. Issue notice to the respondent. The petitioner, respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 22nd October.
Obliged.
48.
My lord, in this case, right order dated 3rd of September, which is at Annexer 1A, page 9. The people please to grant interim protection, my lord. Subsequently, my lord, we came to know that on 31st of August, on the prayer of the IO, additional section 345 of the Explosive Substance Act at page 14, lordship will find that, madam. And section 7 of Essential Commodities Act has been incorporated.
So what is your prayer?
My prayer is that, my lord, these sections may be included in the earlier that order, my lord, with subsequent to
No,
that.
why it is required? You are already on bail.
But am I
Interim bail.
Lordship?
Is it interim bail or absolute bail?
Interim bail, madam.
Till
I was
the-
granted interim protection.
the AB case. Oh, when is the Putul AB case?
Fixing 2925 for production of the accused person.
When it is fixed?
It is fixed on, my lord, 24th of September for production of case time.
Okay, now what is your prayer?
But my prayer is that these sections, additional sections, I was not granted bail, my lord. My apprehension is that in respect of this.
No, you are granted bail in a case, not against section. Still, till the protection is there, you may not be arrested. You have to amend the bail application.
Yes, but for bringing on record this additional section, I'll submit an amended post title, madam.
And this application is for?
For bringing on record these additional sections, madam, in connection with the bail application. Because we are not aware of the dates of passing of this order about adding of the additional sections, madam.
Okay, you want to amend the bail application. By this application itself, we will allow.
Yes, ma'am.
You heard Mr.
Chakraborty.
T. Chakraborty, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This interlocutory application has been filed by the petitioner, petitioners, namely Abul Ali, alias Abul Ahmad, and Rubul Ali, who were granted interim bail by order dated 3/9/2024, passed in connected AB case number 2140/2024 in connection with Sibsagar PS case number 119/2025 under section 61 within bracket 2/305 within bracket small e /287/288/125 within brackets for small b of BNS, read with section 20K of the Petroleum Act. Learned counsel for the petitioner has submitted that the petitioner has come to know that by order dated 31/8/2025, passed in Sibsagar PS case number 119/2025, the learned judicial magistrate first class Sibsagar has allowed addition of section 3/4/5 of the Explosive Substance Act 1908 and section 7 of the Essential Commodities Act 1955 for the aforesaid case. In view of above, the learned counsel for the petitioner has submitted that the petitioner may be allowed to allow this, you have orally submitted, allowed to file an amended cause title in the anticipatory bail application number 2140/2025 to bring on record the addition of said aforesaid penal provision. Stop. The prayer is allowed. The petitioner may do so by filing an amended bail application / cause title before in the amended bail application / cause title in AB case number 2140/2025 before the next date fixed, on or before the next date fixed. That is 24/9/2025. With above observation, this interlocutory application is disposed of.
I'm obliged.
49.
And there, I filed a petition, my lord, under 438 for quashing. And honorable court has, honorable office said that there is a delay of 69 days. So I filed one IA, my lord. So I pray the notice may be allowed.
Heard Mr. S.C. Vishwas for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. Respondent is only state.
Yes. So state to reject the notice, my lord, only.
You are objecting.
It will be condemned.
This application under section 5 of the condonation, 5 of the Limitation Act 1963 has been filed by the petitioner for condoning the delay of 69 days in preferring the connected criminal revision petition, by which the petitioner intends to impugn the order dated 27/1/2025 passed by learned Judicial Magistrate First Class Kachar in PRC case number 18/2025. Within bracket corresponding to Silchar PS case number 19/2024 under section 182/199/211 of the Indian Penal Code. Stop. Where is the reason for delay?
Reason is the fail to contact the lawyer here because lawyer has lost his mobile phone.
Where have you mentioned?
Para 3.
And what was the order, impugn order?
Impugn order was that my lord, non-bailable warrant of arrest issued on the same day, my lord.
Okay.
On the day of charge sheet, when it was issued non-bailable warrant.
Learned counsel.
PNA.
Learned counsel for the petitioner has submitted that the petitioner has mentioned the cause for the delay in approaching this court beyond the prescribed period of limitation in para 3 and 4 of the application for condonation of delay. Stop. Learned additional public prosecutor has submitted that considering the cause shown for the delay, the state does not intend to oppose the delay condonation application. I have considered the submissions made by learned counsel for both sides. Considering the submissions made by learned counsel for both sides, as well as considering the cause shown by the petitioner for approaching this court after 30 days beyond, how many days?
90 days, 69 days.
69 days beyond the prescribed period of limitation. This court is of considered opinion that the grounds shown in paragraph number 3 of the application filed by the petitioner can be regarded as sufficient cause for preferring the connected criminal revision petition. Belatedly after 69 days beyond the prescribed period of limitation. Accordingly, the delay of 69 days in preferring the connected criminal revision petition is hereby condoned. Stop. The registry is directed to register the connected criminal revision petition and list the same for admission on a date to be fixed by it. This interlocutory application is accordingly disposed.
Register the revision, madam.
Yes, I have said so. The registry is directed to register the connected criminal revision petition.
62 form supplementary.
So this revision is against the order passed by the appellate court, dismissing the appeal and affirming the judgment of the trial court. NIA matter, what happened, this matter, there is a delay of 1,168 days, in filing the revision petition. And petitioner is behind the bar. He was arrested on 15/6/2025. And
notice will have to.
Yes, notice will go, but I am only praying, my matter is perhaps similar with the item number 45, I have heard. So, can it be fixed on on next Monday so that I can take Dusty's service, because 6 months conviction was there, and petitioner as of now, he is behind the almost 93 days.
Dusty service in criminal matters.
Quasi-criminal NIA matter, That is, and he is ready to pay the amount also, now. And he was not aware about because the appeal was dismissed during the lockdown, Appeal was dismissed on 29/10/2020 when whole country was under lockdown.
Okay. You take steps through
Registry as well as Dusty for permissible. Because quasi-criminal laws it can grant.
But you have been imposed sentence.
Yes, So I am behind the bar,
Heard Mr. N.K. Kolita, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under Section 5 of the Limitation Act has been filed by the petitioner, praying for condoning the delay of 1,168 days in filing the connected criminal revision petition. Whereby he intends to impugn the judgment dated 29/10/2020 passed by London Additional Session Judge number 2, Kamrup Metro in Criminal Appeal number 154/2019, which whereby the judgment of the judgment passed by London Judicial Magistrate First Class on 5/8/2019 in CR case number 2934/2015 was affirmed. By the said judgment of the trial court, the petitioner was convicted under Section 138 of the NI Act and was sentenced to undergo rigorous imprisonment for 6 months, and was also directed to pay a fine, a compensation of rupees. How much?
Well, it is 3,400. It is
Rupees 3,03,400. And in default of payment, such payment, to undergo simple imprisonment for further period of 2 months. Learned counsel for the petitioner has submitted that in the meanwhile, petitioner has already been apprehended in execution of non-bailable of warrant arrest. Non-bailable warrant of arrest issued against him by the trial court, and presently he is behind the bars. And therefore, he has submitted that in addition to usual process, the petitioner may be allowed to take steps for issuance of notice through the STI mode. He has submitted that this may be allowed as the proceeding under section 138 are in the nature of quasi-criminal in nature. Stop. Let the notice be issued. The petitioner shall take steps for issuance of notice upon the respondent number 2 through the officer in charge of jurisdictional police station. The said notice shall be routed through the registry of this court. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 25/9/2025. Further, considering the submissions made by learned counsel for the petitioner, the petitioner is also allowed to take steps for service of notice through the STI mode upon respondent number 2. List accordingly.
But instead of 25, can it be 23 or 24?
Well, I'm sorry to trouble you. Sorry.
And 63 also, my lord, same party, my lord. Case number is different. my lord.
Punishment,
Same, my lord.
amount,
Amount is different, my lord. 4,98,557.
63 rema agonism, similar to the earlier order, and the amount would be 4 lakh.
4,98,557. And criminal appeal number, it is 165.
Criminal appeal number
165 of 2019.
and NI case
NI and CR number, my lord, 1501.
150. एक का change over, बाकी as it is. Okay.
I'm sorry, my lord. Why dictating? I can't.
And my lord, 63 also, my lord. Amount is 3,03,400.
$64.
64 is also same.
64 amount is?
Amount is 3,03,400. And appeal number, my lord, 155 of 2019. And CR number 2935 of 50. 29.
Okay, same order.
Yes. Sir. And another one is there, my lord.
65. What is the amount? 65.
3,03,400.
No, 64 is 3,03,000.
Yes, my lord, 65 also, my lord.
3,03,400. Okay. Appeal number?
And appeal number 166 of 2019. And CR number 2932 of 15.
15. Okay, same order.
All right.
I'm sorry,
Yes.
my lord, while dictating the order of item number in connection with item number 48, the date of interim order was recorded as 2024. It will be 2025, 3/9/2025, my lord.
Item number 48. আপনি লিখেছেন? Who took the dictation? Abhishek. Impugn order to 2024 হবো। লিখিত। Okay, I'll make correction.
I'm deeply, I'm sorry to drop double by.
This one. Item 22.
Yeah, please, your lordship. My lord, here, my lord, we have changed the order passed by the learned court below, my lord, against the maintenance to be paid by the husband, my lord, to the wife. Now, the instruction that we have received, my lord, that the wife has remarried.
You are husband?
I am husband, my lord.
Okay.
Now, I would like to file, my lord, an additional affidavit to that effect. So, my lord, I need some time.
No, if she has remarried, you approach the magistrate court by filing 127 application.
Correct, my lord, but since it is here, my lord, we have, it is also our duty to, my lord, incorporate all these.
No, we'll
facts.
disclose it of today itself, giving you liberty to approach. If conditions have changed, then you can approach the trial court.
That is why, my lord, let me confirm it, my lord,
Okay.
once again.
Okay.
So I pray some time.
Okay.
Your lordship, I'm for the respondent, your lordship. I don't have the copy of your lordship, copy not been furnished. Criminal revision petition number 491 of 2023. That copy is not-
I'll furnish it, my lord, today itself.
No, have you remarried?
Lordship, I don't have the definite information, your lordship.
Okay.
So I also take some time,
Okay.
your lordship. To the other side.
Heard Mr. B.K. Sen, learned counsel for the petitioner. Also heard Mr. A.A. Devan, learned counsel for the respondent. Learned counsel for the petitioner has submitted that the petitioner has been informed that the respondent has remarried again. And on that ground, he submits that he needs some time to get a confirmed information and then file an additional affidavit to bring on record the said facts. On the other hand, learned counsel for the respondent submits that he has not yet received the copy of revision petition.
I have furnished, my lord, right now.
Okay.
Just yes, sir. So now also I need to
Stop.
go through.
The learned counsel for the petitioner has immediately furnished the said copy to the learned counsel for respondent in the court itself. Considering the submissions made by learned counsel for the petitioner, some time is granted for the purpose of filing additional affidavit by the petitioner. Let this matter be listed after 3 weeks. 3 weeks on a date to be fixed by registry.
All right.
May I please, your lordship?
My lordship, it's a question of fire to this petition, my lordship. I've given a written form of synopsis of my. Two petitions, my lordship.
In the first petition, I have challenged the FIR, and then the next petition, I have challenged the charge sheet, my lordship. The synopsis of arguments, I have,
This is item number
my lordship,
23.
20. Two petitions.
23 and second petition is
Second petition is 156, my lord, both are not listed together. Criminal petition one.
both have to be listed together.
Yes, my lord, so this should be listed here, why is it not listed?
You have filed two criminal petitions.
Yes, my,
One challenging the FIR,
yes, my lord,
other challenging the charge sheet.
charge sheet, my lord.
Both are required to be listed
Yes,
together.
my lordship. So short date, my lordship, because yesterday, my lordship, some of this, my lordship, kindly see this Muzammil Haq, my lordship. He again came to my house, which is goons, my lordship, and some of the goons entered my house. So it is entirely, my lordship.
That is not the subject matter.
No, my lordship, the police is required to give the status report. From 6 months, they are not giving a status report.
Case diary is there.
Lordship, records were called for. It is already charge sheeted, Lordship.
Charge sheet is.
Status report against the case which we have filed, my lordship.
No,
Police
that is
ignoring
beyond the purview of this.
that. Directed, my lordship. Court has directed. Because both the cases are connected, my lordship.
Lordship, their counter FIR, Lordship, that has no relation with the present.
Court
issue,
has,
Lordship.
after seeing that, my lordship, court
They
has
are challenging-
directed to produce
Lordship,
that.
they are challenging
Kindly
the
see earlier
FIR.
orders, my lordship.
Lordship, they are challenging the FIR and the charge sheet. We will have to restrain ourselves to that issue only, Lordship. What they have filed, Lordship, has no resemblance to
This
this.
third person, my lordship, Muzammil Haq, my lordship. Proxy FIR, this one, my lordship. This FIR has been filed by one Mufiza Ahmed and signed by Muzammil Haq. This is, he is indulged in business of land, my lordship. Honorable court in a repeatedly asked the police to submit the status report of the case filed by us, my lordship.
What is the case? Dispur PS case number 1158.
Yes, my lordship.
That diary was called for.
Yes, my lordship. We,
That has not been received, Lordship.
Okay, let it come.
but from my lordship, from several occasions, my lordship, court has directed, kindly see earlier orders, my lordship. Why they are repeating, my lordship? And yesterday also, the person, the goons of that Muzammil Haq, my lordship, entered our house. Only because today this case is listed, my lordship.
Heard
Unmarried woman, my lordship.
Mr. S.V. Laskar, learned counsel for the petitioner. Also heard Mr. V. Sharma, learned additional public prosecutor, as well as
Registered complaint.
Mr. U.J. Soikia, appearing for respondent number 2. Learned counsel for the petitioner has submitted that the instant criminal petition is connected with
My lordship.
another criminal petition filed by the petitioner, that is criminal petition number 156/2024. However, same has not been listed. Today, he submits that both the criminal petition, namely criminal petition number 1375/2024, as well as 156/2024, are required to be heard together as it relates to the same police station case. And in one case, FIR has been impugned, and in other case, charge sheet has been impugned. Stop. Considering the submissions made by learned counsel, registry is directed to list the criminal petition number 156/2024 along with the instant case. It also appears that by order dated 27/2/2025, the scan copy of the case, scan copy. I send it. Scan copy of the case diary of 1158/2025. 1158/2023 was called for. However, same has not yet been received. It appears that the scanned copy of the records of PRC case number 1359/2024 is there on record, has been received. Let a reminder be issued for the scanned copy of the case diary of 1158/2023. This 1158/2023 has been charge sheeted.
My lordship, no, my charge sheeted is, my lord, this one, charge sheet dated 7/4/2024. FIR dated
Charge sheeted.
23/6/2023.
And what is the PRC case?
PRC case number, lordship, 1359/24.
Learned additional public prosecutor has submitted that the charge sheet has been laid in this for PS case number 1158/2025, 2023. And the connected PRC case is PRC case number
PRC case number
1359.
1359
24.
/2024. Pending in the court of learned
CJN.
Chief Judicial Magistrate Kamruk Metro. Let the scan copy of the aforesaid record be called for from this said court. Please this matter.
My lord, on the last occasion, my lordship, the honorable court also directed them to produce the status report of case CR last annexure 19 may be seen, page 66. Page 66.
Status report of 588.
My lordship, this is the case number 588/2023 complaint case, and because police refused to register the FIR, then we filed complaint case. After that also police refused to register FIR.
No.
Then Honorable High Court directed the police to send the status report. They are not sending the status report, my lord. Why they don't want to file FIR against that, in spite of having.
No, just a minute. In CR case number 588/2023.
Yes, my lord.
What has happened?
My lordship, I am unmarried.
No,
We
I
filed
don't need
case-
it. You have filed a complaint case.
Not complaint. FIR we filed before, but the police refused to take the FIR.
Then you filed this CR case.
Yes,
Then
then the honorable court forwarded the matter to the police for registering the case. Till date, it has not been registered.
Then
After he-
have you complained to the magistrate?
My lordship, we have also filed complaint. Let me annexure, my lordship. And after that, direction has been issued. I'm going to annex my
Stop.
lordship.
London. Counsel for the petitioner has further submitted that the CR case number 588/2023 filed by the present petitioner has been forwarded to the which police station?
Dispur police station, my
To
lordship.
the Dispur police station by the learned Chief Judicial Magistrate Kamruk Metro by its order dated 27/10/2023 with a direction to register an FIR and conduct investigation. The status report of the said case was called for from the Court of Learned Chief Judicial Magistrate on the last occasion. However, the office note dated 13/8/2025 shows that only scanned copy of the PRC case number 1359/2024 has been received. As such, let a reminder be issued to the Court of Learned Chief Judicial Magistrate, Kamrup Metro, to send the status report of the investigation status report of the case which was registered on the basis of order dated 27/10/2023, passed in CR case number 588/20, list on 17th of October.
My lord, short date, because yesterday, my lordship, I am unmarried woman, my lordship. Yesterday, this third person, this Mujammal,
You file an FIR. You have
we went to FIR, my lord, police are with them, my lordship. That's why we are going to magistrate. Magistrate forwarding the FIR, they are not doing anything. This is the government land NRC there, in the government record, my name is written, my lordship. I have annexed.
status report on 25th of October.
Kindly see, my lordship.
25th of October.
Highly obliged.
Rima, এই order to চাব লাগিব. Some corrections will be required.
Highly obliged.
24.
Lordship, in this matter, Mr. Deenath is appearing. He is on legs in court number 3, Lordship. May be passed over for the time being.
I will take my chances because it's a detention order, 1 year period. It's already expiring in December. I would take my chances for your lordships.
PIT NDPS.
Yes, my lord. Therefore, I'll take my chances. If your
Okay.
lordships are passing it over, I'll wait because otherwise we'll be running short of time to again hear it on any other day, my lord.
Okay.
Or else I can start, my lord.
Pass over for the time being.
I passed over for the time. I'll wait. I'll take my chances, my lord. Extremely clear.
25.
May it please. This is a statutory appeal against the conviction of 10 years under the NDPS. So your lordship may be.
Heard Mr. Y.S. Mannan, learned counsel for the appellant. Also heard Miss N. Kakoti, learned counsel for NCB. This appeal under section 415 of the BNSS 2023 has been filed by the petitioner, by the appellants Hira Kumar and Ratan Laskar, impugning the judgment dated 29/3/2025 and order dated 1/4/2025, passed in. This is within limitation.
Limitation already condoned.
Okay.
There was 38 days.
Okay.
delay. It has been.
Passed in NDPS case number 68/2021 by the Court of Learned Additional Session Judge number 1, Kamrup Metro, Guwahati, stop. By the impugned judgment an order, the appellants were convicted under section we
Convicted under section 20B to C.
20B to C, read with section
Section
29 of the NDPS Act. And were sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh, and in default of payment of fine to further undergo rigorous imprisonment for 3 months. This appeal is admitted. Let the records of the trial court be called for. Since Ms. N. Kakoti has appeared for the respondent NCB, no formal notice need to be issued to the respondent. List this matter after receipt of trial court records.
There is an I also. For suspension and bail.
You'll file objection
They might file.
because there,
Yes.
this embargo of 37 will be
Yes.
coming
They will,
in IA.
in that, this case notice may be issued. Your Lordship.
Yes. In IA, this interlocutory application has been filed under section 430 of the BNSS, praying for suspension of sentence imposed on the applicants by judgment and order dated 29/3/2025 and 1/4/2025 respectively. In NDPS case number 68/2021 by the Court of London Additional Session Judge number 1, Kamrup Metro. By the said judgment and order, the applicants were convicted under section 20B to C/29 of the NDPS Act and were sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh, and in default of payment of fine to undergo further rigorous imprisonment for 3 months. Issue notice to the respondent. Since Ms. N. Kakoti has appeared for the respondent, that is NCB, no formal notice needs to be issued against the said respondent. Stop. London counsel for the respondent submits that has prayed for some time for filing a written objection against the prayer for suspension of sentence and bail made by the applicants. The prayer is allowed. Let this case be listed on 25/10. No, after
the vacation.
After vacation. 24/10.
Obliged.
26. My lord, this petition has been, this criminal appeal has been filed, my lord, against the acquittal of the accused, my lord.
Against acquittal.
My lord, 302 cases there. This
by the victim?
Yes, by the victim, my lord.
Okay. Heard Mr. B. Chetri, learned counsel for the appellants. Also heard Mr. K.K. Das, learned additional public prosecutor. This appeal under section 413 of BNSS has been preferred by Srimati Kenmaya Devi against the judgment of acquittal. No, against the judgment dated 16/6/2025, passed by the Court of Learned Session, Additional Session Judge within bracket FTC, Sonitpur, in Sessions Case number 87/2020, whereby the respondent number 2, 3, 4, and 5 were acquitted in the said case. Issue notice to the respondents and call for the records of the trial court along with the connected case diary. Since Mr. K.K. Das has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards other respondents are concerned, the appellant shall take steps for issuance of notice upon said respondents by registered post with AD as well as by usual mode within a week from the date of this order, returnable after 4 weeks. List accordingly. Last item.
Not anything on late.
We will defer it unless both are present before vacation date. You need a fixed date or let the registry fix?
I would be grateful if a date can be given because the date is anywhere expiring after 1 year. I think if it is not inconvenient.
When
for
it
your-
will expire?
My lord, this is 5th of December 2024, the order was passed. It's in only 1 year. It's already September now. Any date that is convenient to us,
Convenient
if
date.
not inconvenient. Even if it is tomorrow, my lord, if your lordships are not, or Friday, any date, my lord.
No, let the registry fix. Heard. This is item number
24, my.
heard Mr. R.B. Fukun, learned counsel for the petitioner. Also heard Miss M. Devi, learned government advocate, appearing for the respondent. Learned government advocate submits that in this case, Mr. D. Nath, learned senior government advocate, would be representing the state government respondent, and he is on legs in a different court, and therefore she prays for an adjournment. Considering the submissions made by learned counsel, the prayer is allowed. Let this case be listed. When do you want?
19th or 23, whatever is convenient to your lordships. Whatever is convenient to your lordships.
Let's see, 19 on 23 is
I'll make an attempt if it doesn't reach his mind, but still.
let this case be listed. 23rd of Divoparini. Let this case be listed on 23rd.
I'm extremely grateful. I'm extremely grateful. Extremely grateful.